Hi everyone, welcome back to Thorough Newspaper Analysis. This is a video for 11th of May 2024. Now let's quickly proceed and have a look at the pointers of discussion for today. So first of all, in the editorial segment, we're going to talk about an Indian Express article which carries the heading, Can Delhi's unaided private schools increase fee without government approval? What the High Court has said in this respect. So essentially, there was a circular which was issued by the Delhi government asking unaided recognized private schools that you seek approval of the concerned department as and when you're increasing your fee. So the Delhi High Court has stayed this particular circular. We'll have a look at the content of the circular and why the High Court has stayed it. This is going to be followed by the second segment of news updates. And lastly, we talk about two legal updates for the day. So without further ado, let's start with the article. Let's have a look at the heading of it first. So can Delhi's unaided private schools increase their fee structure without seeking government approval? What the High Court has said. Let's have a look at the context of it. So the Delhi High Court has recently stayed a Delhi government circular. What was the content or the crux of that circular? It essentially said that private unaided schools, which were allotted land by the government agencies, they needed prior sanction from the Directorate of Education before increasing their fee for the current academic year, which is the academic year of 2024-2025. A single judge bench of the High Court also sought response from the Directorate of Education on the plea which was filed by an organization of these sort of schools, and this organization is called Action Committee Unaided Recognized Private School. The hearing is placed on 31st of July. We'll have a look at the proceeding that are going to unfold before the High Court when the hearing comes up. So we need to understand that there was a judgment of the Supreme Court which goes back to 2004, which provided essentially for the fact that there should not be commercialization of education. Now, in the current stay order, the High Court did make a reference to this judgment also. We'll have a look at all of these details in a bit. But first, just have a look at, let's just understand what was the core crux of the circular. So the circular was issued on 27th of March, and it stated, and I would like to quote it out, no private unaided school in Delhi which has been allotted land by the government agencies shall enhance fee without the prior sanction of the Director of Education. This circular relied on Section 17 of the Delhi School Education Act of 1973. What was Section 17? It essentially provided that no aided school shall levy any fee, collect any other charge, or receive any other payment except those which is received, which is specified by the director. Here, when I say aided school, it means a recognized private school which receives maintenance, which receives aid in form of maintenance from center or administrator, any local authority or any other authority which is designated by the government. And by director, we mean this is the defining clause, Section 2, Clause G. It means the Director of Education, Delhi. Subsection 2 of Section 17 further provides that every aided school which is having different fee rates, other charges, or different funds has to seek prior approval from the authority before levying or collecting them. Further, subsection 3, it places a requirement of manager of these recognized schools that before each academic year, you file a full statement. Full statement of what? Of the fee which is to be levied by these schools during the ensuing academic session. Except with the director's prior approval, such schools, they cannot charge any fee in excess of what is specified by the statement or in the statement. Now let's talk about what the circular said on private unaided schools. So the circular, as we've already noted here, it called for the heads of these private unaided schools to submit their proposals to increase their fee so that the same can be approved by the Director of Education. The circular added that these schools, they were allocated land by the landowning agencies on the very condition of seeking prior approval or sanction by the Directorate of Education for increasing their fee. The circular also specified the timeline and the procedure for submitting this proposal, And it further added that schools are strictly directed not to increase any fee until the sanction is conveyed. And in case they do so, that is, they increase the fee without seeking the consent or approval, then that would be strictly dealt with and it will be taken as a very serious matter. Now, please note, while the High Court stayed this particular circular, the High Court made reference to its 2019 order. Now, what was this 2019 order? Let's have a look at this. This is because very important, and we'll see what the High Court had to say to the Directorate of Education for not following its 2019 order. So the 2019 order was given in the case of Action Committee Unaided Recognized Private Schools versus Directorate of Education. It was a similar matter where, there was a circular which was issued directing them to seek a prior approval. Now, after having heard the matter back in 2019, this is what the High Court said. The High Court, it essentially set aside this circular, allowing private, unaided and recognized private schools to hike their fee without seeking the approval of the Directorate of Education, irrespective of whether these schools were situated on the land which was given at concessional rates by the government. So essentially, the High Court back in 2019 did not agree with the circular and stated that these schools, they can increase their fee structure so long as there is not profiteering or commercializing. That this order, which was still in position, currently existing, currently valid, in spite of the fact that this order was present, this circular was issued, which required these schools to seek approval. So therefore, the Delhi High Court reprimanded the Directorate of Education for doing so. So let's see what the High Court categorically said in this respect. Saying that respect for judicial pronouncements, it is one of the pillars of the structure, the edifice, the foundation of the rule of law. The court also pulled up the Directorate of Education, saying that the 2019 judgment had to be respected no matter however dissatisfied the Director of Education was with it. The attitude of Director of Education in continuously issuing circulars threatening these schools with action in the event of their increasing their fee without obtaining the prior approval of the Directorate of Education, it is absolutely objectionable and it cannot be allowed. Further, please understand this we've already had a look at, but the High Court also made reference to the 2004 verdict of the Supreme Court in the case of Modern School versus Union of India, wherein the Supreme Court categorically held that a balance was required between maintaining institutions' autonomy and preventing the commercialization of education. Saying that such commercialization must be prevented, the court had said that unaided educational institutions, they enjoy greater autonomy in the matters of determination of fee structure, and they were entitled to a reasonable surplus in development of education and expansion of the institution. And with this, now we proceed to the next segment of national news. So let's start with the first update in the national news category. India surpasses Japan as the third largest solar power generator for the year 2023. For renewable energy, India has overtaken Japan to become the third largest solar power generator in the entire world for the year 2023. Let's talk about the other position bearers. So India's generates nearly 5.8% of its electricity from solar power, thereby surpassing Japan and ranking only behind China, United States, and Brazil. So the rankings are as follows. We have China, followed by United States, Brazil, and India. IREDA, which is the Indian Renewable Energy Development Agency, it establishes subsidiary in GIFT city of Gujarat. So the Indian Renewable Energy Development Agency, which is a state-owned entity under the Ministry of New and Renewable Energy, it is now formed a subsidiary. The name of the subsidiary is IREDA Global Green Energy Finance IFSC Limited, and this was done at the International Financial Services Center within the GIFT city of Gujarat. RBI lifts restrictions on Bank of Baroda's BOB World mobile application. The Reserve Bank of India has announced the lifting of restrictions on Bank of Baroda's mobile application, which is called BOB World. This decision follows the RBI's directive in back last year of October to suspend customer onboarding on the application due to supervisory concerns. The Bank of Baroda, in response, has undertaken corrective measures to address these concerns, and as a result, these restrictions are now lifted. CUSAT researchers, they have discovered new marine tardigrade species. Cochin University, it has identified new marine tardigrade species. So let's first talk about what is tardigrades. See, these essentially are often called the water bears, and these are 8-legged micro animals which are found in the water. So a new species of these tardigrades, it has been discovered by Kochi University researchers and scientists, and they've been named as Batalips Kalami, and it is named after our former Prime Minister and one of the greatest scientists that our country has seen so far, Dr. APJ Abdul Kalam. Super Earth astronomers detect rocky planet with atmosphere. So astronomers, they have detected a thick atmosphere around a planet that's twice as big as our home, which is the Earth, in a nearby solar system. The so-called super Earth, which is known as the 55 Canceri, it is among the few rocky planets outside our solar system with a significant atmosphere, wrapped a blanket of carbon dioxide and carbon monoxide. Manipur launches School on Wheels initiative for students in relief camps. So amidst the aftermath of ethnic strife and the severe hailstorms in the state of Manipur, the government there has introduced the School on Wheels program and the initiative. This is aimed at providing education to students in shelter homes and who are sheltered in these relief camps across the state. This initiative, it entails a mobile educational setup which is equipped with a library, then through computers, and then sports items accompanied by a teacher to visit various camps so that, while they are sheltered in these relief camps, their education is not affected at all. Indian Army and the Indian Air Force, it has conducted joint exercise in Punjab. Indian Army's Khagra Corps, under the aegis of, which is the support of Army's Western Command, it successfully conducted a 3-day joint exercise with the Indian Air Force at multiple locations across the state of Punjab. Indian Navy, it is to hold maritime exercise with Singapore Navy. Indian Navy, it is looking forward to further enhancing its operability with the Singapore Army and understanding of each other's operational philosophy by holding joint maritime exercises. India leads global remittances, surpassing $100 billion mark. India, it has emerged as the global leader in the remittances in the year 2022, receiving over $111 billion, surpassing the $100 billion mark for the very first time. The International Organization for Migration, it highlighted India alongside Mexico, China, the Philippines, and France as the top 5 remittance recipient countries. Renowned Urdu writer, he passes away. So who is he? Sheikh Salam Razzaq. He is a renowned Urdu literature, which means he's somebody who is, extremely knowledgeable when it comes to the field of literature. An academician. He's popularly known for his pseudonym, which is Salman bin Razzaq. He passed away at his residence in Mumbai after a prolonged illness. This news is from UK. With this, we transition to the international news segment. Nadeem Zahawi, he announces decision to stand down at general election. He was sacked last year by UK Prime Minister from position of Conservative Party chair after he failed to disclose His Majesty's Revenue and Customs investigation into his tax affairs, and he was found to have violated the ministerial code. Amul becomes official sponsor of Sri Lankan men's cricket T20. Sri Lanka Cricket has announced that the Indian milk producer brand Amul It has been appointed as the official sponsor of Sri Lankan men's team for the duration of ICC Men's T20 World Cup 2024. Now, this has brought us to the legal segment for today with the first update coming from the Honorable High Court of Jharkhand. Let's have a look at the name of this case. It is Bablu Tirki versus the state of Jharkhand. Let's talk about the heading of this case. Unless prosecution proves case beyond reasonable doubt, burden of proof cannot be shifted to accused. The Jharkhand High Court has overturned the judgment of a trial court in a murder case while highlighting the necessity for the prosecution to establish its case beyond a reasonable doubt. We all know that in criminal matters, the prosecution has to discharge a very heavy burden of proof which is cast upon him, which is beyond reasonable doubt. And once that is done, then the matter goes to the defense. The matter is now the discharge of burden is shifted to the accused side, and accused has to prove the preponderance of probability in his favor. So the division bench said in this respect that unless and until the prosecution has proved beyond reasonable doubt its case, then the burden of proof upon the accused under Section 107 of the Indian Evidence Act, it cannot be shifted. 107 essentially provides that if any fact is within the special knowledge of somebody, then that person has the burden of proving the fact. So hearing from the prosecution evidence the presence of the appellant prior or on the fateful night of the homicidal death of the wife of the appellant in his tenanted room being not proved, the burden of proof under Section 106 of the Evidence Act cannot be shifted to the appellant convict. So from this verdict, for exam purposes, what we need to note is this, that before we can ask the person who has the special knowledge under Section 106 to prove the fact which is within his special knowledge, the prosecution has to discharge its burden of proving the case beyond reasonable doubt. Next up is an update from Supreme Court. Arvind Kejriwal should not visit CM's office or Delhi Secretariat during interim release period till 1st of June. So while directing interim release of the Delhi Chief Minister Arvind Kejriwal in the matter of Delhi excise case of the liquor scam case from judicial custody till 1st of June, the Supreme Court imposed the following conditions, which is he was to furnish bail bond in the sum of rupees 50,000 with one surety of like amount. He shall not visit the office of the Chief Minister and Delhi Secretariat. He shall be bound by the statement made on his behalf that, he will not sign any official file unless it is required and necessary for obtaining clearance and approval of the Lieutenant Governor of Delhi, along with other conditions. The name of this case is Arvind Kejriwal versus Directorate of Enforcement. And with this, we come to an end of TNA. Thank you so much for watching. Have a wonderful day ahead.